Amendment 7. Jury trial in civil lawsuits. Passed by Congress September 25th, 1789. Ratified December 15th, 1791. The first 10 amendments form the Bill of Rights. In suit and common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Common interpretation. The Seventh Amendment by Rene Leto Lerner and Shuja A. Thomas. To many Americans, jury trials seem to be the normal way of deciding civil cases. Television programs and movies show exciting scenes for juries deciding important non-criminal disputes involving individuals, government officials, and companies. The reality is different. Jury decide less than 1% of the civil cases that are filed in court. The lack of jury trials may seem strange, as the Seventh Amendment guarantees the right for jury trial in certain civil cases. There are two main types of court system in the United States: federal and the state. The Seventh Amendment requires civil jury trials only in federal courts. This amendment is unusual. The U.S. Supreme Court requires states to protect almost every other right in the Bill of Rights, such as the right to criminal jury trial. But the court has not required states to hold civil jury trials. When the police and the St. Louis Railroad Corporation was boundless, 1916, nearly all of the states, however, have rights to civil jury trial in certain cases in their state constitutions. The United States is almost the only nation that continues to require civil jury trials. Civil juries, seen to those in the United States, are not part of the legal traditions of the continental Europe or the legal system derived from those traditions, including in Latin America and Asia. Even in England, these former colonies of Canada, Australia, New Zealand, civil jury trials virtually being abolished. Why did some persons at the founding of the United States think that the civil jury trial was so important that it should be guaranteed in the federal and the state constitutions? To understand the Seventh Amendment, we need to go back into history and the English legal system. Much of the legal system in the United States, and especially the provisions of the Bill of Rights, are based on Americans' English roots. The civil jury was an old English institution, older even than the criminal jury. Since the Middle Ages, the English had used juries of persons not trained in law to decide certain civil cases. There were always some English courts that did not use juries. In this court, judges decide cases. The most important of these juryless courts was the Chancery, also known as equity. In the 18th century, as the desire of American colonists for independence from Britain grew, the jury in America became more important. The British government claimed that Americans had to obey laws enacted by the British Parliament, in which Americans had no representation. Americans did participate on colonial juries, and these juries became a way for Americans to govern themselves. As tensions with Britain arose, juries nullified, refused to follow hated British laws, especially laws for collecting taxes, because colonial juries had been valuable in the struggle against Britain. Americans put right to civil and criminal jury trials into the new state constitutions immediately after declaring independence in 1776. By the time the Federal Constitutional Convention met in Philadelphia in 1787, opinions about the civil jury were more mixed because the state civil juries had been sympathetic to debtors. Federalists, in particular, feared the nullification of the laws of contract. For this as other reason, the Federal Constitution that was presented to the states for ratification did not include a right to civil jury trial. In the states ratifying conventions for the Federal Constitution, Anti-Federalists strongly protested the lack of a right to civil jury trial. They expressed concern about debtors and also argued that juries could protect litigants from ban laws passed by the legislature, tyrannical actions by the executive, and corrupt or biased judges, fearing that the Second Constitutional Convention might be called if a right to civil jury trial was not included in the Federal Bill of Rights. James Madison drafted what became the Seventh Amendment. The Seventh Amendment had two clauses. First, known as Preservation Clause, provides in suit and common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. This clause set out the type of cases juries are required to decide. The second clause, known as the Re-examination Clause, declares, no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This clause prevents federal judges from overturning jury verdicts in certain ways. The term common law, used twice in the amendment, can be confusing. Today, the term common law often means law declared by judges and opposed to law enacted by legislatures. In the Seventh Amendment, the term common law means law and procedures of courts that use juries, as opposed to equity in other courts that do not use juries. Interpreting the Seventh Amendment, judges soon encountered a problem. To which common law courts was the amendment referring? The states had different civil jury practices, and the federal courts were new. The United States Supreme Court announced a solution. The term common law in the Seventh Amendment meant the common law of England, Parsons versus Bedford, 1830. A century later, the Supreme Court formally declared that the amendment was to be interpreted according to the common law of England at the time the amendment was ratified, that is, in 1791. Dimick versus Shedd, 1935. This interpretation is known as a historical test. Generally, the type of case that a jury decides the way the judges and reviews their verdicts are supposed to resemble the practice in English common law courts in 1791. The Supreme Court stated that the amendment preserves the substance of the right, not mere matter to form or procedure. Baltimore and Colonial Line Corporation versus Raidman, 1935. Departures from the English practice in 1791 have been permitted, including using 6 jurors instead of 12. Colgrove versus Barton, 1973. Our individual statements will examine the questions of why civil jury trial has become so rare, and what should be done about it. Matters debate. The first perspective, the problem of the Seventh Amendment and the civil jury trial, by Renee Leto Lerner. The civil jury today is almost extinct. Changes to the way courts apply the Seventh Amendment are not going to revive the institution. Civil jury trial and the process leading up to it is so long, expensive, and unpredictable that almost no party wants to use it. Party would rather have a decision by a judge or more often reach an agreement and settle the case. Civil jury trial has always had serious shortcomings. It's only become deeper with time, and reform can resolve them. This is why the civil jury either has never existed or have virtually disappeared all over the world, including in the United States. It would be better to repeal the Seventh Amendment to focus on improving investigation of facts and decision-making in civil cases. The political reason for the civil jury. The joint statement explained that Americans at the time declaring independence wanted the civil juries mainly for a political reason. After the revolution, then the political reason became much weaker. Colonial and revolutionary Americans praised the civil jury for its ability to nullify or refuse to follow hated British laws, especially laws about taxes. While Americans were under British rule, juries went away for Americans to govern themselves after independence. The American people formed the federal and the state republics and governed themselves through elected officials in legislatures and the executive. The representative function of the jury became less important. Jury nullification turned out to be deeply problematic in a self-governing republic. In the American Republic, the people elected representatives to make and enforce laws. Not only that, but the laws were made according to carefully designed mechanisms specifying constitutions, themselves ratified by the people or their representatives. Why should 12 persons have the right to nullify laws made in this manner? Once the Revolutionary era was over, many Americans began to regard the civil jury not so much as mini legislature, but as a way of deciding cases. The political observer Alexis de Tocqueville wrote that the jury could be regarded either as a political institution or as a judicial institution. Alexis de Tocqueville, Democracy in America. Although he praised the jury's political role in educating citizens, Tocqueville suggested as a judicial institution, a way of deciding civil cases, the jury had significant shortcomings. The intrinsic shortcomings is the jury has a constant need for an alternative. Judges have always understood that ordinary juries have difficulty understanding cases involving complex facts and law. Also, juries need mainly oral evidence from witnesses, and jurors' ability to understand written evidence well is not assured. Jurors must hear all evidence in the case at once and decide all issues at once, despite potential confusion, because it is not practical for jurors to keep coming back to court at different times. Furthermore, it's difficult to crack the jury verdict on appeal because jurors give no official reason for the decisions. The English common law developed various ways to try to cope with these shortcomings. There were rules called pleading rules that limited the number of parties that could appear in a single jury case, the number of claims a party could make, how complex a claim could be, and what remedy was available. Cases that went to a jury generally concerned only two parties. One claim for money damages, one most a few simple questions of fact. A judge could comment on the evidence in the case to help the jury understand. And the common law, almost the only remedy for the jury making a mistake was to order a new trial. A new trial was time-consuming and expensive because the case had to be tried all over again with a different jury. But this was some way to crack the jury error. Obviously, many disputes were more complicated and could not adequately be resolved this way. English judges developed an entire separate system to handle more complicated disputes, with decisions not by juries, but by judges. The main alternative system was called equity. The system of equity decided many important disputes, including questions of mortgages, bankruptcy, fraud, trust, and business associations. See John H. Limbing, Renee Letter, and Bruce P. Smith, History of the Common Law, the Development of Anglo-American Legal Institution. Equity was able to administer more complex remedies like injunctions ordered from court to do something or not to do something. Besides giving money damages, by the 18th century, judging equity had to give written reasons for their decisions, and those decisions could be appealed. The Seventh Amendment is based on the distinction between common law and equity. The amendment states that its requirements concerning jury trial apply in suits to the common law, not equity. Jury trial is even more poorly suited to deciding modern civil cases. Civil jury trial has always been pragmatic, but changes have occurred since the late 18th century to make jury trial even more difficult and rarer. Here are some of the most important disputes that can go to a jury are more complicated and confusing. Because states and federal government had merged the system of common law and the equity, the old common law restrictions on cases going to a jury are gone. Now juries can hear cases involve many parties, many claims, and complicating suits. Technology has grown more complex and business transactions are more intricate. Evidence increasingly written, numerical, or scientific form, which is often difficult for jurors to understand. Judges have lots of power to comment on evidence to the jury to help jurors understand the case. Jury trials have become longer and more expensive. In part from dispute becoming more complex, the adversarial system in the United States has slowed down jury trial. Changes include extensive procedure for selecting jurors, such as questionnaires, and in-person questioning called voir dire, elaborate rules, evidence, dueling expert witnesses, a long, complex instruction to the jury on law. Jury trials are often a heavy burden to jurors, their families, and their employers. Trials are often unnecessary because parties now have many ways to get information before trial. In common law, there are a few ways for a party to get information about the case before trial. Trial was needed to find out what happened. The price was a major problem. After the merger of common law and equity, parties have many ways to get information before trial, all taken into equity. It's a method called pretrial discovery. This information helps parties to settle and make trial seems unnecessary. A judge now can decide before trial that a party does not have enough evidence to go to a jury in a procedure called summary judgment. There was no summary judgment under common law because there was no pretrial discovery. In the 18th century, judges did not know what evidence a party could produce in trial. Pretrial discovery changed that. Civil jury trial was nearly gone in the United States for good reason. Promising reforms are developing in investigating and resolving civil disputes. This could be more thorough and effective without the remaining hindrances of the Seventh Amendment. The next perspective, the fall of the civil jury, by Sir J. Thomas. As we explained in the joint statement, the Supreme Court had declared that the substance of the English common law jury trial right in 1791 governs the meaning of the Seventh Amendment today. Accordingly, the civil jury in the United States should essentially resemble the 18th century English jury. The important question about the Seventh Amendment concerns whether the court has correctly determined the substance of this past English jury trial. That is, has the court properly divided the decision-making authority in the federal government between juries and judges by one, allocating or permitting certain cases to be decided by judges instead of juries, and two, permitting judges to use new procedures that ultimately take cases away from juries. Let's first examine some of the matters that the Supreme Court had permitted judges to decide. When such a case involved public rights, the court had labeled as public rights certain claims that Congress created through legislation. An example of the public right includes the government alleging a company violated federal law. In cases such as these, judges here in administrative agencies in the executive department, instead of a jury determining if the government wins, how much money it will receive. And thus, Roofing Corporation versus Occupational Safety and Health Review Commission, 1977, Ingersham, federal judge rules SEC in all judges' appointment to likely unconstitutional. But in the past, juries, not judges, decide this type of case in which the party brings the lawsuit could receive money. The Seventh Amendment preserves the jury trial right in suits and common law, where the value in controversy shall exceed $20. In late 18th century England, with very rare exception, juries in common law courts decided who won, how much money would be received for the damage that the party suffered. Juries also heard new claim created by the English Parliament for which the remedy for money damages was available. In every court, by contrast, judges did not decide how much money to award. Instead, they decided questions such as whether to grant a remedy for the breach of contract called specific performance. Here, to honor a contract that has been violated, a judge would order someone to sell a horse or to be removed from land, because juries decide monetary remedies in common law courts. A judge determines other types of remedies in equity courts. The Seventh Amendment preserves juries' authority to decide money issues. See James Oldham, trial by juries, the Seventh Amendment, Anglo-American special juries. The Supreme Court has shifted other authority from juries. When cases are under jury's authority, using new procedure, judges can dismiss cases before, during, and after jury trials by deciding that the existing evidence does not support the claims that the people brought. One such a procedure called summary judgment. Using this procedure, prior to jury trial, a judge can decide if insufficient evidence exists and dismiss the lawsuit. In 18th century, in England, the judge could not take case away from the jury under the circumstances. A judge will assess the sufficiency of the evidence only after a jury trial. There was insufficient evidence of the claim, the judge would order a new trial before another jury. When the judge threw a case out of court, specific circumstances were required that rarely occurred. The person who disputes the claim admitted the fact that the conclusions of the opposing party evidence, and the court determined whether there was a claim under those admissions. For example, see the English case of Gibson versus Hunter. With the past only loosely governing the jury's authority, the executive, the legislature, and the judiciary now hold power that the English jury formerly held. As a result of this shifting power, the jury cannot properly protect against abuses of governmental power. Although some argue that the past or English practice should not govern the civil jury trial right, it is important that this be used to guard the jury's authority. The civil jury, like the traditional branch of government, has no ability to protect its own power. For example, by convening itself, deciding cases. If the English 18th century historical connection is not restored, the branches will continue to take cases from juries, and juries will hear few cases in federal court. See Shuja A. Thomas, Missing American Jury, Restoring its fundamental constitutional role. Juries also decide few cases in state court. As described in the joint statement, many state constitutions guarantee a jury trial in certain civil cases. Important question concerning whether the U.S. Constitution itself requires juries in civil cases in state courts. Under the 14th Amendment, if a right is deemed fundamental, states are required to protect the right. The Supreme Court Sorry for the interruption. Let me continue. Under the 14th Amendment, if a right is deemed fundamental, states are required to protect the right. The Supreme Court has decided that the civil jury trial right is not a fundamental right, so states are not obligated to hold civil jury trials. However, the court has acted differently with respect to other rights, except for other jury rights, every other right in the Bill of Rights that the court has been determined to be a fundamental right. For example, recently, in the case of McDonough versus Chicago, 2010, the court recognized the right to bear arms as a fundamental right that states must protect. Evidence of the founding through the 14th Amendment's adoption actually shows the civil jury right was a fundamental right respected by the British, the founders, the 14th Amendment's framers, and the states. As a result, under the authority of the U.S. Constitution, states should hold jury trials in all types of cases, including small claim matters where states currently do not require juries.